First is that I would like to personally, along with other members of the committee, I believe, represent or introduce and welcome our newest member, Representative Bridges. Welcome to the committee. I don't know what you did to anger leadership, but I think you'll find the Administrative Regs is a interesting committee, and like me, you will learn a lot in this committee. But welcome, and we appreciate you being here. If you are joining us via video conference, please mute your microphone until it's time for your regulation to be heard. Otherwise, sound interference can occur with the person who is testifying. Please silence your cell phones if you're in the room. Any other questions, introductions, announcements before we get started? Seeing none, please call the first regulation.
Under Boards and Commissions, Board of Medical Licensure, 201 KAR 9081 with amendment.
This regulation amends to include physician assistants and make sanctions discretionary rather than mandatory in accordance with the board's operating statutes and a recent court decision. The staff suggested amendment amends various sections to correct statutory citations and comply with the drafting and formatting requirements of KRS Chapter 13A.
Would you please identify yourself for the record? Who do we have?
Please remember to unmute your mic as well.
Leanne? Do we have Leanne? Leanne, you're talking, but we can't hear you. Leanne, we still cannot hear you.
I think she logged off so she could log back on.
Okay.
She's not there anymore. Until we get Leanne back, we're going to move to the Board of Architects, 201 KAR 19 215, 220, 225, 230, 235, 240, 245, 250, 255, 260, 265, 270, 275, 410, 415, 420, 425, 430, 435, 440, 445, and 450, all with staff suggested amendments.
This package of administrative regulations expired previously, and following expiration, the agency filed regulations to reinstate language previously in effect. All 23 of these regulations have staff amendments. These amendments all amend various sections for clarity, to add statutory citations, and to comply with KRS Chapter 13A. Additionally, 201 KR 19220, 235, 255, 265, 415, 435, and 445 update and add various material incorporated by reference. 201 KR 19245 amends Section 1 to delete the reference to the duplicate certification fee. 201 KR 19255 amends Section 2 to delete fees relating to the failure to notify the board of a change in information and for duplicate documents, and to clarify methods of payment to include payments by credit and debit card, and delete the requirement for a check to be certified. 201 KR 19260 amends Section 7 to add language in to include advertising through the internet or other electronic means. 201 KR 19435 amends Section 1 to delete reference to reinstatement fees, and amends Section 2 to delete reference to inactive status fee. 201 KR 19440 amends to delete the fees for reciprocal certification, reinstatement, inactive status, reactivation of an inactive license, and a duplicate certificate.
I believe we have several individuals ready to testify on this set of regs. Would you please identify yourself for the record?
Good morning. My name is Cordelia Harbert. I'm the Executive Director of the Kentucky Board of Architects. Thank you for having me.
Thank you.
I'm Ann Tyler Morgan, Legal Counsel for the Board of Architects.
Thank you.
Good morning. I'm Stephanie McCreary, President of the Board of Architects and a certified interior designer.
Thank you.
My name's Larry Brandstetter, and I'm a board member.
Thank you so much. Do we have any questions from any members of the committee? And I've gotten ahead of myself. Let me slow down just a little bit. We do have staff amendments. Is there a motion for approval of the staff amendments?
So moved.
Is there a second?
Second.
Without objection, it is so ordered. Now, are there any questions from members of the subcommittee on the regs or the staff amendments? That's one of the great things about an early meeting. If you're first in line, you don't get a lot of questions. Do any members of the board, do the Board of Architects representatives need to say anything, or are you fine with moving on? Sounds great. Move on to the next regulation. Thank you.
Thank you all.
Education and Workforce Development Cabinet, Department of Education, 701. She's still not here. Okay. 701 KAR 5150, 702 KAR 1190 Emergency, 702 KAR 4090, 704 KAR 3035, 305, and 325. All except 702 1190E have staff suggested amendments.
7015150 is being amended to require prospective NTI districts to incorporate an NTI plan within the CDIP and remove language distinguishing between initial and renewal NTI applicants. 702-1190 emergency establishes the authority for local school districts to grant paid emergency leave to employees, including emergency leave related to the COVID-19 state of emergency. 702-4090 is being amended to clarify the process by which local boards of education dispose of surplus real property to explicitly include the required steps for a district to obtain fair market value for the property in one location. 704-3035 is being amended to correct outdated information and align with other administrative regulations for consistency. 704-3305 is being amended to change the minimum high school graduation requirements for students entering 9th grade in the fall of 2019 and remove language relating to post-secondary readiness indicators and a minimum score on a nationwide summative assessment as requirements for a high school diploma. 704-3325 is being amended to update language to align instructional leadership training program and provider content to the professional standards for educational leaders. 704-8100 establishes the academic standards for library media and incorporates by reference the Kentucky academic standards for library media for use in Kentucky's common schools. The staff suggested amendments to these regulations amends various sections to comply with the drafting requirements of KRS Chapter 13A and make technical changes.
Thank you. Would General Counsel, is General Counsel Allen there?
Good morning. Yes, Todd Allen, General Counsel for the Department of Education and State Board of Education.
Thank you, Counsel Allen. I see on my sheet here that you are here representing Department of Education, and you have a lot of backup, it appears, today. We have,
I do, just in the event that there are any questions.
In the event of a problem, we've got 11 people ready to respond here. So there are staff amendments on this set of regs. Do we have a motion for approval of the staff amendments?
Motion.
We have a motion. Do we have a second on the staff amendments?
Second.
We have a motion second. Without objection, it is so ordered. Are there any questions from members of the subcommittee concerning these regulations as they pertain to the Department of Education? We have Co-Chair Hale.
Thank you, Mr. Chairman. The only question I have is regarding 702-190 with the emergency clause attached to it.
Yes, sir.
Okay. I didn't know if anybody was hearing me or not. Could you just quickly explain that to me again? What and the reasoning for the emergency attachment there, please.
Certainly. So 190, the District Employee Emergency Leave Regulation, is a mechanism to provide school districts additional flexibility to provide, if they so choose, additional paid emergency leave to their employees as a result of the coronavirus. This emergency regulation was put in place at the request of school districts and school staff across the state as a result of the expiration or Senate Bill 177 that was passed by the General Assembly during your last regular session to provide relief to school districts as a result of coronavirus. That only applied to the last school year. Of course, at the time that that was passed, I think that everyone had hoped and thought that we would be beyond coronavirus when we started this new school year, but that turned out to not be the case. So this is a regulation, an emergency regulation. It needed to be in place in an emergency situation because it needed to go into effect immediately upon the beginning of this current school year to provide school districts the flexibility to grant additional paid emergency leave days if their local leadership elects to do that.
Mr. Chairman, may I follow up, please?
Please proceed.
Yes, sir. Thank you for that response. And then the only other question I'd like to ask on that is, so this was basically not the department implementing this emergency reg. I mean, I know you implemented, but it was with the consulting of the school districts, and so the districts themselves basically were the ones that were seeking this emergency.
Yes, sir, absolutely. This does the same thing that Senate Bill 177 did for school districts. It allows them to decide whether or not they will provide additional paid emergency leave to their employees. And you will note that we did receive one comment in response to this emergency regulation. It was from the Kentucky School Boards Association, of which I think nearly all school boards in the state belong, and it was supportive of the regulation as filed.
Thank you, Mr. Allen. I appreciate that very much. Thank you, Mr. Chairman.
Thank you. Any other questions on this set of regulations? Seeing none, please call the next regulation.
Public Protection Cabinet, Department of Insurance, 806 KAR 2095, 806 KAR 10030, 806 KAR 12010, 20, 150, and 180, 806 KAR 13020, 806 KAR 38100, and 806 KAR 47010. All of these with staff suggested amendments.
806-2095 through 47010, update insurance requirements related to collecting local government premium tax, surplus lines reporting and tax payment structure, advertising, fair disclosure to consumers, annuity disclosures, military sales practices, excess rates, risk-based capital for health organizations, and fraud prevention. The staff suggested amendments amend various sections to comply with KRS Chapter 13A.
Would the representative from the Department of Insurance please identify themselves for the record?
Good morning. My name is DJ Wasson. I'm the Deputy Commissioner at the Department of Insurance.
Thank you so much. We have a staff amendment. We have staff amendments. Is there a motion for approval of the staff amendments?
So moved.
We have a motion. Do we have a second?
Second.
We have a motion and a second. Without objection, it is so ordered. These regulations obviously most of them deal with insurance and insurance practices. Do we have any questions from members of the committee regarding this set of regulations? Seeing none, please call the next regulation.
Thank you.
Public Protection Cabinet, Horse Racing Commission, 810 KAR 3020 and 811 KAR 2120, both with agency amendments.
810-3020 amends to establish that a licensee fails to meet financial responsibility requirements if the licensee has an unsatisfied judgment that is related to any part of horse racing, to remove the requirement for an out-of-state judgment to be domesticated, and allow anyone to bring forward a complaint of financial irresponsibility. The agency proposed amendment would amend the financial responsibility rule in Section 12 to state that a licensee is deemed to be in violation if the licensee fails to satisfy a final unappealable judgment for goods, supplies, services, or fees used in the course of any occupation for which a license is required or directly relating to horse racing, including boarding, breeding, consigning, equine-related supplies, farm leases, feed, and transportation. It would also allow anyone to bring forward a complaint of financial irresponsibility, including a successful plaintiff or third party, with knowledge through the presentation of a final unappealable judgment from a state, federal, or administrative court. 811-2120 amends to update the agency name and make other minor technical corrections. The agency proposed amendment would amend Section 1 to add a definition for show horse, would amend Section 2 to require Kentucky affiliates to have an IRS 501c designation, to require one member of the advisory committee to have established knowledge of gaited horses. It would require re-registration of Kentucky affiliates. A Kentucky affiliate who is the National Breed Organization would be required to obtain certification by an independent third party or by the commission at a fee of $120 per hour. It would require certified horses to have parentage verified by DNA and would require certification data to be provided to the commission electronically. It would also amend Section 3 to require the commission to notify the Kentucky affiliate of the total dollars allocated to that affiliate. It would require a Kentucky affiliate to notify the commission of the names of incentive winners, the horses registered to that affiliate, and the date of each registration. It would require the commission to generate claim forms within 30 days of notification. It would also require a Kentucky affiliate to provide the forms to its incentive winners and to certify that the required notification has occurred. It would amend Section 4 to require the semi-annual report to include a list of all horses registered, current board members, and current contact information. And finally, it would amend Section 6 to allow the commission to bar registration for violations from 1 to 20 years based on the severity and repetition of violations.
Thank you. We have individuals here from the Horse Racing Commission. If you're out there, if you would identify yourselves for the record.
Thank you. This is Jennifer Wolsing. I'm at the General Counsel at the Kentucky Horse Racing Commission.
Gilfoy, the Executive Director, Kentucky Horse Racing Commission.
Chad Thompson, Deputy General Counsel with the Kentucky Horse Racing Commission.
And we are also waiting on Jamie Eads. She has been having connectivity problems, but she is the Deputy Executive Director at the Horse Racing Commission.
And she just indicated me she got back on.
Thank you so much. Just so you know, our order of process here today, we will first take up KAR 3020. And so we have two regulations here. We're going to take those up separately. So if you would, go ahead and begin your presentation. This is not a regulation that's new to this committee. So if you would, please take up 3020 first and explain that regulation to us, please.
Thank you. The Commission's financial responsibility rule is important to protect businesses in the horse racing industry from insolvent or recalcitrant debtors. Our regulation requires the presentation of an unpaid, unappealable, and final judgment against a racing participant. Therefore, when the Commission takes action under its rule, there should be no further dispute as to whether the debt is owed. In a recent case captioned Jamgotchian versus Kentucky Horse Racing Commission, Judge Wingate held that the Commission's regulation, as currently written, does not allow the Commission to address financial responsibility complaints regarding debts arising from non-licensed businesses. However, prior to that decision, the Commission had interpreted its regulation to include non-licensed occupations. In fact, in the past 9 years, almost half of our verified financial responsibility complaints were related to non-licensed occupations, such as boarding and horse supplies. The Commission's proposed regulatory revision is intended to clean up its regulation to function as it was originally intended and how we have been interpreting it for close to a decade or more. Our goal is to protect all businesses in the horse racing industry from doing business with individuals who are either insolvent or unscrupulous, not just those businesses that happen to be licensed by the Commission. The Commission's current agency amendment should address all concerns raised at the November 9th and December 3rd our meetings. We are hopeful that you all will feel comfortable approving the current amendment. Specifically, we were directed to be less open-ended and to put up some guardrails. We did so by actually listing various occupations which do not require a license, but which are protected under the proposed agency amendment. As a result, we believe that this will hem in the Kentucky Horse Racing Commission's discretion, and it will not lead to superfluous litigation.
Thank you so much. As you noted, there is an agency amendment. So you have spoken on the reg and the agency amendment. It has not been adopted at this time. However, we're taking these things in a certain order. And at this time, I believe he came on. I would like to welcome Senator Yates. If you can announce yourself, Senator.
Thank you, Mr. Chair. Senator David Yates, District 37 from Jefferson, and I do apologize. There was an issue with the link. My legislative assistant came down and got that. But thank you for having me.
So, are you in Frankfurt? Are you in the LRC?
No, I'm via Zoom from a home office right now.
Okay, we will note that you are present, and you at this time you are able to vote on regulations. Welcome to the committee. Like I told Representative Bridges, I don't know what you did to irritate leadership, but we welcome you to this committee and look forward to working with you.
Happy to be here.
Having said that, we do have a gentleman signed up to speak against this set of regulations. Representative Hellringer, if you would come forward and make your presentation. Former representative, I always say that. And thank you for making your monthly trip over to Frankfurt.
At such an early hour, too. Thank you, Mr. Chairman. As you noted, and members of the committee, for the record, I'm Bob Hellringer. I'm representing myself here. I'm not representing the client. And again, for the third month in a row, I do want to say I'm appreciative of the counsel for the commission sending me this amendment and asking for my input. It's been somewhat of a collaborative effort since the first meeting. I did send back to Ms. Wolsing my issues with the now third version of this regulation. I didn't get a response, so I guess that means here we are. Let me just say for the record that I don't have any objection to the paragraph 5 that talks about that anybody can bring to the commission's attention the fact of a judgment against a licensee. I think they could do that now, but because that's how it got started with the case that I had that most of the committee is now familiar with. A lawyer for the creditor sent a letter to the commission and said, we have a judgment against Mr. Jamgachian. We want you to revoke his license. There was no authority in the current regulation for the Racing Commission to even acknowledge that letter, but they did, and they acted on the letter. So number 5 is really not necessary, but I don't have any problem with it. Paragraph 4, I have a problem with. And here's the essence of the issue, okay? Since we started this little melodrama, I have tried to inform the committee of the issues with financial responsibility. Initially, the commission wanted to greatly expand its authority to go beyond its legislative mandate to regulate horse racing, okay? The current financial responsibility regulation allows the commission to revoke, suspend, or deny a license if an applicant's financially responsible because of a judgment that they owe money to another licensee, okay? They initially proposed really licensing horse breeders so they could bring them into that definition. They've now abandoned that because this committee would not go along with it, basically, and in an attempt to go around the court case that Ms. Wolsing talked about and to retaliate against my client. I think if they get this or any other kind of regulation, they're going to suspend my former client's license as an owner. And I don't think, I think actually this Section 4, this new Section 4, is an enhancement and a great expansion of what they were trying to do initially, where they wanted to include the breeders as the equivalent of a licensee. Now they don't need a license. They're named in here. If they board horses, breed horses, consign horses, if they sell equine-related supplies, if they have farm leases, all of these people, which have nothing to do directly with horse racing, now they're going to be under the authority of the Racing Commission to enforce judgments. And this is a huge enhancement of their authority beyond the scope of what the legislature a long time ago authorized the commission to do, and that is to take forceful control of horse racing and how that's conducted in this state. It's totally unnecessary for letters F and G. Feed men, van drivers, they go on the backside. They're required to have a license. So if a trainer owes or an owner owes money to the feed man, to the van company, they're already included in the current definition of financial responsibility that the commission can get involved in. So again, as I've said consistently on this issue, the Racing Commission is attempting to greatly enhance its authority in this area, and I don't think it's necessary. If you'll recall, Mr. Chairman, the last meeting we were here, Senator Rocky Adams asked a question, how many cases like this have you had in the past that you would need this regulation? And I believe Ms. Wolsing said that she had checked into that, and it was one or two over going back several years. So this is clearly an attempt to get around a decision by Judge Wingate that I think was absolutely correct. The commission chose not to appeal that ruling, even though they obviously disagreed with it. And they're coming before you trying to greatly enhance their authority well beyond what was at stake in the Jamgotchian case, and to allow them to, in the guise of keeping the sport honest and that kind of thing, greatly enhancing their authority to enforce judgments and to require licensees to pay judgments in full before they get a license and before they're allowed to make a living on the racetrack. And lastly, my last point is that I don't think it's even limited. The language of this regulation, it sets out A through G, these examples, but if you look at the body of the proposed amendment, it says a licensee's failure to satisfy a final unappealable judgment rendered against him or her for goods, supplies, services, or fees used in the course of any occupation directly relating to horse racing, such as the following. They could say later, include a whole list of other occupations and claim that that's part of such as. These are just a few individual examples, and such as is broad enough to encompass lots more. I just don't think it's necessary. I think the current, as I've said since November, the current financial responsibility regulation is enough, is sufficient. It involves allowing the commission to enforce and get involved in judgments between licensees. And that's what their role should be. If a trainer, like I said, owes somebody on the backside, a blacksmith, a feed man, a van driver, any of those kind of things, they should be brought before the stewards, brought before the commission. If a jockey agent is owed money by a jockey, those are disputes between licensees, and they have that authority and should have that authority to intervene in those matters. But other than that, I would submit to you that boarding, breeding, consigning, equine-related supplies, that could be anything. They buy twine at Walmart. I mean, that's an equine-related supply, okay? Is just far beyond what this body allowed the Racing Commission to do. Back in 1906, when they first passed a bill to set up a racing commission. Thank you, Mr. Chairman.
Thank you.
Mr. Chairman, may the Racing Commission briefly respond?
You may. Please proceed.
Thank you. I think Mr. Hellringer, with all due respect, may have misinterpreted or forgotten my exact testimony the last time. I was asked approximately how many of these non-licensed occupations are actually brought before the Kentucky Horse Racing Commission. I took a look at the past 9 years of verified financial responsibility complaints. We had 79 in the past 9 years, and of those, almost half related to non-licensed occupations. I believe the exact number was 38, which is a far cry from just 1 or 2. In addition, Mr. Hellringer suggests that the KHRC is seeking a great expansion of our authority under this proposed agency amendment. In my opinion, that is absolutely incorrect. Our authority would not be expanded. We're simply seeking to regulate our licensees. If they have a debt with a non-licensed occupation that directly relates to horse racing, then that is a proper subject of the Racing Commission's authority. Mr. Hellringer also discussed the term such as and suggests that could include a lot of completely unrelated professions or occupations. I respectfully suggest that is incorrect. Under the canons of statutory interpretation, you have to take a look at a list, and you have to only have things that are very similar to those things listed in the list. So, for example, when we talk about boarding or breeding, that wouldn't include things that are far afield from the profession of horse racing. In the last couple of ours meetings, we discussed subjects like personal home mortgages, we discussed child support. Clearly, those would be far afield from the list of items here in A through G. We also noted that these occupations had to be directly related to horse racing. Therefore, if it's something like twine, that in his example from Walmart, that's something that's not directly related to horse racing unless there was some very strong connection proven. And I frankly cannot imagine that Walmart would suggest that there should be a financial responsibility complaint about an undue or an overdue bill for twine. Finally, Mr. Hellringer talked a little bit about Mr. Jamgotchin and the concern that the Kentucky Horse Racing Commission would retaliate against his client. I can tell you that there is absolutely nothing further from the truth. We have no desire to retaliate against Mr. Jamgotchin. And in fact, our goal is simply to clean up this regulation. We've been interpreting to include unlicensed occupations for years and years and years. Judge Wingate told us that interpretation was incorrect, and we simply want to change the regulation to match our original intent.
May I respond briefly?
Yes.
Mr. Chairman, thank you. I sat where you all are sitting, never where you're sitting, Mr. Chairman. We were in the minority, but sat
it's
in
not
these
all
rows.
It's cracked up to be.
Yes, thank you. And I heard a lot of testimony in 23 years, and I was on the Judiciary Committee for 20 of those years, and I heard a lot of witnesses say that despite what's in a bill, they don't want to do what they're proposing in the bill. And, sitting where you are, we would always kind of look at each other like, wow, then why do you need the bill? Well, we just want it. Maybe in case or whatever, but we don't want to do anything that's in the bill. So when I hear Ms. Wolsing say, we're not going to do anything to Mr. Jamgotchin, a little alarm bell goes off, but they want the authority to go after Mr. Jamgotchin, someone like him, who has a judgment against him, not from a licensee, but now someone under this much broader category that has nothing to do directly with horse racing. And that is far greater. They need to get a bill passed, frankly, that will really give them the authority to not only regulate horse racing, but now any equine activity that leads to horse racing, however they want to define that. But to try to tell this committee respectfully, I'm trying to be respectful, that they're not going to do anything to anybody despite having this authority that they want. And if they didn't need it, they wouldn't be asking for it, okay? I'd just be a little suspect of that, frankly. And so, again, I think this is far afield from what they're supposed to be doing. This is going to put them in the collection business for all of these entities, and it's very broad what this encompasses. And, you know, all these creditors are going to come running to the commission and say, suspend this guy's license. He owes us money, from a little amount to large amount. And if they decide they're not going to do that, that may lead to litigation. If they do decide to do it, that's going to lead to litigation. They're going to have to defend these actions before the Franklin Circuit Court. It's going to require more work, more time, more staff to address now this new authority that they're seeking to get into the collection business. And I think it's wrong. I thank you.
Thank you. This time, the committee will allow for discussion and questions of the regulation and the amendment, even though the amendment has not been adopted. Do we have any questions from members of the committee? Co-Chair Hale.
Thank you, Mr. Chair, and thank you, Mr. Hellringer, for being here with us again this morning, and the commission as well. We have two new members on this committee this morning for the first time, and I'm sure they're probably wondering what we're talking about here. But for the past 3 months, November, December, and now January, we, as this committee, have sat here and basically heard the same things presented from the Horse Racing Commission. And Mr. Chairman, I guess this is more of a comment than a question, but the situation was, we had some really good questions that were brought forward by Representative Marzian and Senator Adams in prior meetings. And I think most of their questions were answered properly, and I think the concerns they had. But here again, we're basically back here on the same issues, with the same issues for the third straight month. And from my perspective, Mr. Chairman, and this is my perspective, it doesn't appear that there has been much of a change at all that has occurred here. And Mr. Hellringer, you have been very consistent in your testimony for the past 3 months. I will say this one was considerably shorter, but your testimony has been very consistent in what you have said to us, and been very consistent in that. And again, I've tried to digest this now for the third straight month to see if there can be things worked out to meet your the situation that you're presenting to us. And it appears that the Horse Racing Commission, in all due respect, has not done that. So, and I'm not going to move forward anywhere right now, but Mr. Chairman, I just wanted to make those comments, and I hope that didn't take up too much time.
Thank you. That's why we came in at 8, so we would have time. Any other members? Representative Bridges.
I know I'm new to this committee, and just dealing with LRC, Bill bill writers and everything in the past take both sides out of this as far as who they are specifically. You know, that section 4, there's three sections in there that I just question, that makes it a very, very broad stroke. It starts off additionally, and then down in the third line it says any occupation such as, so it's just throwing out some examples. That's pretty broad. And I think if I took that to bill writer, they would say we can't do that. So I don't know, and this has nothing to do with either party testifying or anything. You just bring some questions, and you know, being new to the committee, I could not make a judgment or a call on this. I'm not saying that, but that's just a red flag that comes up that is a very, in my interpretation, a very broad stroke to be given over to a regulatory rather than being in statutory that's more definite and defined, that allows a court to be able to follow that in specific measures. But that's just my thoughts.
Thank you. We have anyone online that has any questions for Mr. Hellringer or the commission? Seeing none, I'll chime in just a second here as chair and as a member. Representative Bridges talks about red flags, and for me personally, there's multiple red flags with this regulation. We talked earlier about the intent of the commission. Well, one thing that we need to worry about here is legislative intent, and is this regulation, if passed, the intent of the legislature? Does it satisfy the legislative intent? Secondly, is this special legislation? So, as a senator representative, we swear to uphold the Constitution. In the Constitution, it says we cannot pass anything that is special legislation, meaning that any legislation, rules, or regulations that would apply and be aimed at one individual. I'm not saying that this is happening, but Mr. Hellringer does make a bit of a case that it could be. Another item on my list is this something that needs to be done through the regulatory process? And the way I see it, this is a big deal. This is a major change to the power of the Horse Racing Commission. And whether you're for or against that, the question remains, is this committee, is this the place to make this change, or is the proper place for that the legislative process and through statute as Mr. Hellringer would propose? As I said, it's a great expanse of the authority of the commission. And the final item on my list, which would tell me that this is very problematic to me, is it's an expansion, I believe, of the court process. And so in reality, what's going to happen is someone, and I'm a real estate attorney, so I'm very familiar with judgment liens and how they're filed and where they're filed and when they're filed. When someone wants a judgment lien, the normal process is to go to the court, proper venue, make your case to the court, and they approve or disapprove your judgment. Once you receive your judgment, you file it in the court records, and you go from there. And there's different levels of appeal in the court process, all the way from district, circuit, court of appeals up to the Supreme Court, if you will. So what we're doing today, if this is allowed to go through, is once a judgment is rendered in the court, as far as a collection judgment, then that will be filed of record. And then let's say that's the plaintiff is unable, the creditor is unable to collect, they're going to have another bite at the apple. So they can go to the Horse Racing Commission and say, he or she is not paying their judgment, strip them of their license. And that's a big deal. That is a very important additional step in the process. And question, is it going to apply equally? Are you going to, is the commission going to treat a large breeder the same as a small breeder? Is the commission going to treat Mr. Hellringer's client the same as any other client? So that's the questions that I have as of right now, and I'll give Mr. Hellringer, if you could respond to my comments, and then I'll come back to the Horse Racing Commission, and you guys can respond to that.
Mr. Chairman, thank you. You're right on with all of those things. And of course, if an individual their license is revoked, if they're not unable to satisfy the judgment in full. If you remember from my case, my client at the time he applied for a license was making payments, court-ordered payments on that judgment that he owed to Coolmore. And the Racing Commission said that's not good enough. That's not good enough. Even though if he failed to make one, even though he couldn't really stop it, it's coming out of his bank account. But even if he did, he would be subject to being in contempt of court, federal court out in California. But the Racing Commission said, that's not good enough. You haven't satisfied it in full, therefore no license. Now, if you do that to a trainer, a groom, a hot walker, an exercise rider, an assistant trainer, they can't make a living. And I think you are exactly correct in all those observations. And the selective part of it, here we are after that case came down. They're here because of what happened. They finally have admitted that. They're here to get around Judge Wingate's decision rather than going through the court system and filing an appeal. They want to do it this way. And I have no doubt, because Mr. Jamgotchian is kind of a colorful figure in racing. He's litigated in a lot of states against the claiming rules, including Kentucky, which he lost. Because of who he is, I feel like he was denied a license first, and then we went to court, and the judge didn't order them to give him a license, but they said you can't use that as an excuse, so they gave him one. But I think there's going to be the potential, anyway, for selective enforcement. They certainly haven't put in this regulation any requirement on their part. This is totally subjective on their part. What case they want to invoke this, what case they don't. It's totally up to them as to whether or not it would apply. And again, for something that broad and comprehensive, I think they need to go to you all and get a bill passed, if they can, to give them this authority expressly. Thank you.
Yes, if the Horse Racing Commission would respond.
Thank you. Initially, one of the questions that you raised is whether this is special legislation or whether the Kentucky Horse Racing Commission has the intent to discriminate or retaliate against any particular individual. I will turn the committee's attention to paragraph 4, which states that a licensee's failure to satisfy a final and unappealable judgment shall constitute a failure to meet the financial responsibility requirements of KRS 230.310. To my knowledge, never in the Commission's history has there been a situation in which we have brought an instance of financial responsibility and the Commission has failed to act appropriately. Certainly, we've investigated these claims to find out if they're accurate, and that's why we talk about verified versus unverified claims of financial irresponsibility. But when we find an actually verified claim, we act, and we act the same way in each particular case. If somebody brings us this claim during the middle of somebody's license period, then we put a hold on that person's license so that when they reapply, they're going to have that hold, and they're going to have to pay off their judgment or somehow come to an understanding with the creditor by making payments in order to get that hold lifted. Similarly, if somebody's application is pending, then again, that hold would be placed in their license. This is not selective enforcement. We have never done that in the past, and there's no ability for us to do that under the proposed agency amendment or in the original version of the amendment that we proposed originally. We would also note that we do not feel that this constitutes an expansion of the court process. The financial responsibility rule has been in place for a number of years. All that we're doing is we are amending it to match the way that the Kentucky Horse Racing Commission has been applying it for at least 9 years. People have had the opportunity to come to the Racing Commission in the past after they have received a final and unappealable judgment and share with the commission their concerns. If those concerns are found to be valid, that the person hasn't paid on that judgment, then we take action. That's how we've done it for years, and that's exactly how we would continue to do it in an equal fashion across the board. I would also note that there have been certain concerns that there will be considerable litigation if this particular agency amendment or if the original amendment is passed by ours or the legislature and LRC generally. In this situation, there's really, if say for instance, the Kentucky Horse Racing Commission says, well, we can't come after you or can't come after a licensee because this doesn't constitute an occupation directly related to horse racing. There's really no opportunity for somebody to file an appeal of that sort of action. There's no standing. There's no individual cause of action that they could assert. As a result, we would argue that there would actually be no litigation arising out of claims that we chose not to pursue. As far as claims that we actually choose to pursue, the licensee would certainly have the right to appeal that judgment, just as Mr. Jamgotchian did. I think that responds to all of the claims made here. However, I would like to turn it over briefly to Chad Thompson to speak directly to some of the concerns about Mr. Jamgotchian.
Thank you, Jennifer, and good morning, members of the committee. Appreciate you guys taking the time to hear us this morning. As Jennifer mentioned, I was going to speak briefly on Mr. Jamgotchian's situation. Just to note that while there is absolutely no retaliatory intent whatsoever towards Mr. Jamgotchian specifically or personally, this is intended to address the situation that was presented with Mr. Jamgotchian if it were to arise in the future, and we believe there's very good reason for that. Mr. Jamgotchian had a judgment obtained against him, a final and unappealable judgment obtained against him in June of 2017. For a period of 2 years, no payments were made upon that judgment at all. Payments began to be made 2 years later in 2019, but only after the entry of a court assignment order requiring those payments to be made. So we do think that situation in which a debtor is actively subverting a judgment for an extended period of time, avoiding paying on a judgment and in bad faith does raise concerns about financial responsibility and is proper for the commission, particularly when you have a judgment debtor like Mr. Jamgotchian who attempted to get licensed with the commission through other means, using his wife, I believe using a separate...
That's totally untrue, Mr. Chairman. That did not happen. She applied for a license in her own name. Now, I'm not going to let him misrepresent my client. He also, that payment plan was in effect and payments had been made. We sent them the ledger sheets and the canceled checks. That payment plan was in effect in 2019 when he applied for his license, not after, okay? The committee shouldn't allow this man to misrepresent my client. Thank you.
And I am not intending to misrepresent anyone. I'm just trying to pass along.
Now we know it's retaliation.
Let's, Mr. Hellringer, let's one at a time here.
That's...
Please proceed.
Beyond the beyond.
There is no retaliatory intent. Mr. Hellringer is correct that payments had been made. I believe 2 months of payments had been made at the time that Mr. Jamgotchian reapplied for a license. But again, that was after a period of 2 years under which no payments had been made. And Mr. Hellringer is also correct that Patricia Jamgotchian applied for a license in her name. That license was denied because of concerns that Mr. Jamgotchian wanted to use her license in a manner to operate under the jurisdiction of the commission.
And then she got her license after, she jumped through enough hoops that they required of her, and that's fine. But she did get her license.
Okay, let's bring it back to the regulation. I think we've covered the specific case now. Jim Gotcha case. So let's bring it back to the regulation at hand. Anybody else from the commission wish to speak in favor of the regulation?
Mr. Chairman, if I may.
Please proceed.
Yeah, Mark Gilfoy here. Mr. Chairman, members of the committee, appreciate the opportunity to speak. I just wanted to just briefly, I guess, make a statement. I've been with the Racing Commission for a little over 34 years. 23 of those 34 years, I was a steward actually in the stand. I still am a licensed steward, so I think I'm the only one here that has actually dealt with this on the steward's level. On these financial responsibilities, there's thousands upon thousands on a daily basis that we take care of at the steward's level. When they'll come to the stewards and say, I need to get my money from so-and-so. I want to, we tell them, well, you got to get a judgment in court. I said, but let me make a phone call before. So we'll call the other party and we'll say, here's what's getting ready to happen. Why don't you just work a deal out with the guy, get payments, go ahead and pay him or whatnot. We don't suspend a license in the middle of the calendar year. If somebody comes to us in July, we will tell the individual as a steward that when you try to get a license for the next year, you're probably going to have a problem. So why don't you go ahead and work something out with the aggrieved? And 9 times out of 10, they do. I think Jennifer said there were 70 or 80 of those that actually made it to the Racing Commission level. Of those, there's probably at least 400 or 500 a year as a steward you take care of. There's no retaliation against his client, Mr. Jamgotchian. And all we're trying to do is keep business going. If somebody owes money to another party in racing, we want to make sure that a financially responsible person is in our sport. There's a lot of money owed to a lot of different people out there, whether it be breed and board and feed, just training bills. We do what's right. Again, I just want to say I've been there for 34 years, 23 of those 34 were as a steward, and there's absolutely going to be no retaliation against anybody. We're just trying to keep racing moving forward and let people pay their bills and be responsible.
Mr. Chairman, could I just comment on Mr. Gilfoyle's testimony?
One final comment.
One final comment. He's absolutely correct. When I was a young lawyer, I did some work for a jockey, some legal work, and he didn't pay me. That was a mistake on his part because one of the stewards at that time at Churchill Downs was my grandfather, who I called, could you do something, And he did. He made a phone call to this jockey, and I got paid like the next day, okay? When you get a call from the stewards, that's really, really important. And anybody on the racetrack knows that. That was true in the 1970s. It's true today. And there was no regulation back then at that time, none. And if there were not any today, this is how life, it's on the backside of it's its own world. Okay, and the stewards run everything, basically. And they do get a lot of requests. I have been paid, a trainer owes somebody, a blacksmith or a veterinarian. Can you do something? Sure, we pick up the phone and we call. And most of the time that produces payment. Okay, so you don't need to, but that's when it was finally promulgated. The regulation did nothing more than put into regulation this practice that I'm describing and that Mr. Gilfoyle described. And so gave them the legal authority to kind of back that up and at least threaten loss of license or revocation or denial of a reapplication if it's between people on the racetrack, on the backside. This isn't that. This is everybody else that deals with the horse outside of a racetrack. There's nobody left out in what they're proposing to do. And so it's not just to codify this practice that Mr. Gilfoyle described. It's way beyond that. This is Coolmore coming in and saying, this guy owes us money. This is a board bill. I mean, this is not necessary to regulate what goes on the backside and to keep the peace on the backside. So
Thank you. Any other members of the committee have a question for Mr. Hellringer or the commission at this time?
Mr. Chair, This is.
Senator Yates.
Thank you, Mr.
You're
Chair.
recognized.
Thank you. I'm doing my best to digest as quick as I can and follow us along. And as I'm listening to testimony, going back and forth, thinking back when I was at the AG's office, we did some consumer protection litigation. And one of my fears right now is the powerful, sometimes, especially we see with the mortgage companies. And I think most of us can say that our constituents, we've all had constituents that weren't able to pay a mortgage through this COVID issue, loss of jobs, and looking at foreclosures. And I'm trying to think of how this may be extended or maybe unintended extensions. So in the event that we have an individual who may have had to purchase additional barn that he's using for the horses, or potentially even land, and he defaults on that, and there's a mortgage lien, would a mortgage company be able to use this as the guys to come in and keep them from being moved forward? I know it's a little bit of a far example, but I do think that while we want to protect the integrity of the racing industry, we also want to protect our constituents that live in Kentucky. And we do not want to be able to use this as a guise to give an unfair advantage to out-of-state corporations, companies, or the powerful. And so as I'm listening to testimony go back and forth, I think that it does seem like, obviously to protect the integrity there, you want to have laws and protections, regulations in place. But to extend that on that we may be given an advantage maybe to out-of-state companies, corporations, or collectors against the individuals living here, to the way that we deprive them of making a living, and that obviously would affect us locally. I think that we may be kind of dancing on dangerous territory. And so I just wanted to make that as an observation of my 20 minutes or so of listening to the back and forth. And I usually want to err in my very short capacity as a senator in 1 week being in here, but a little bit as a local legislator, is I usually err on being as narrowly tailored as possible, and then coming in, and if we have to expand, we do. Thank you, Mr. Chair.
Thank you. Any other questions from members of the committee, remotely or in person? Seeing none, at this time, after hearing all the testimony, and I'm going to make a motion, and the reason for my motion, the main reason is, to me, this is not the proper venue to make this determination. This is a great expansion of the Horse Racing Commission's authority, and this is a big deal. And in my opinion, this needs to flow through the process. This needs to have a committee hearing both in the House and Senate, and the commission needs to make their case there. And if they can get a bill filed and it can pass through both chambers, then so be it. That'll be the law of this state. But I don't feel personally that this is the intent of the legislature, and I feel that this is outside the scope of the regulatory process. So because of that, I personally would make a motion to find this particular regulation deficient.
Second.
I have made a motion for deficiency, and we have a good second. Now, the matter before us is the finding of deficiency. Is there any discussion on the deficiency? Seeing none, all those in favor of the deficiency will vote aye, and those opposed will vote no. It takes 5 votes in favor of the motion for it to pass. Please call the roll.
Senator Rocky Adams. Senator Kerr.
Aye.
Senator Yates.
Aye.
Representative Bridges.
Aye.
Representative Frazier.
Yes.
Representative Hale.
Aye.
Representative Marzian. Senator West.
Aye.
With 6 votes, the motion passes.
Thank you. Now, thank you, Representative Hellringer.
Thank you, Mr. Chairman, members of the committee.
And members of the commission, thank you. We have taken care of that particular reg, but we do have business as it pertains to 811-2120, quarter horse, paint horse, Appaloosa, and Arabian racing. Would you please call that regulation?
811 KAR 2120 with an agency amendment.
Sorry, thank you. There is an agency amendment for this regulation. Would you please explain the agency amendment?
Certainly. This is kind of an interesting regulation. The KHRC has participated in meetings with its constituents for years about the KHBIF regulation, and we were always focused on the possibility of amending it to better serve the regulated community. We ended up filing some technical amendments in September of 2020 to just avoid expiration under our regulation sunset provision. So we then continued to have meetings with the regulated community and came up with the proposed agency amendments that are presented today. We emailed these proposed amendments directly to people in the regulated community, and we also provided them to everyone on our Reg Watch list. And then after that, we had an informal public hearing on December 22nd, and we accepted written comments through December 23rd. We then wrote up a summary in response to comments, which was submitted to the LRC. And essentially, the two major changes that we are proposing to our regulation are as follows. We originally required a letter from the National Breed Organization that represents any particular breed, and that letter would certify the number of horses 25 years of age and younger that were in the breed and resided in Kentucky. Our proposed amendment states that if the Kentucky affiliate is the National Breed Organization, then we need an independent third party approved by the commission to certify the number of horses. So essentially, we're trying to keep all of the affiliates on the same plane by having someone who's a little independent to look at that number of horses. And obviously, if the Kentucky affiliate can't find an independent third party for whatever reason, then KHRC staff can certify those numbers at a fee of $120 an hour. For a horse to be in addition to that, and the other major change is that if a horse is included in the certification, then the horse has to be the result of parentage verified by DNA verification of either the horse's sire or dam, and we would require a 3-generation pedigree on one side. We have some other notable changes as well, but those are the major changes. At this point, we think we have a lot of buy-in from the regulated community on these proposed amendments.
Thank you. Before us, we have the agency amendment. Is there a motion on the agency amendment?
Motion.
We have a motion. Do we have a second?
Second.
Second.
We have a motion and a second without objection. It is so ordered. So we do have before us the regulation 2120 with as amended by the agency amendment. Any other questions from the committee on this regulation? Seeing none, please call the next regulation, and thank you to the Horse Racing Commission. We appreciate your indulgence.
We have reestablished communication with the Board of Medical Licensure, so we'll call 201 KAR 9081 with staff suggested amendment.
This regulation amends to include physician's assistants, make sanctions discretionary rather than mandatory in accordance with the board's operating statutes and a recent court decision. The staff amendment amends various sections to comply with KRS Chapter 13A.
Thank you. Would you please identify yourself for the record?
Yes, good morning. This is Leanne Diakoff, General Counsel with the Board of Medical Licensure.
Good morning. We're glad to hear you today, and welcome back.
Thank you. I apologize for the difficulties.
No worries. There is a staff amendment. Do we have a motion for approval of the staff amendment?
Motion.
We have a motion. Do we have a second?
Second.
We have a motion and a second without objection. It is so ordered. Do any members of the committee have any questions related to the Board of Medical Licensure? If just as a note, this was the very first reg that we called, and we're just coming back to that. It's 201 KAR 9081. Do we have any questions from members? Seeing none, please call the next regulation. Thank you.
Thank you.
Department of Housing, Buildings and Construction, 815 KAR 2150 and 815 KAR 35015, both with staff suggested amendments.
815-2150 amends provisions for inspection and testing related to plumbing to establish remote inspection provisions and add material incorporated by reference. The staff suggested amendments amend Section 3 to comply with KRS Chapter 13A and clarify due process procedures. 815-35015 amends the procedures to obtain and maintain certification as an electrical inspector to clarify that a master electrician actively engaged in the electrical trade immediately preceding an application for electrical inspection certification shall have satisfied the examination requirements. The staff suggested amendments amend various sections to comply with KRS Chapter 13A.
Yes, if the members from the Department of Housing, Buildings, and Construction would identify themselves for the record.
Morning, Chairman. Benjamin Siegel. I'm the General Counsel of the Department of Housing, Buildings, and Construction.
Thank you. Do any members have any questions pertaining to these two regs before us? Seeing none, we do have staff amendments. Is there a motion for approval of the staff amendments?
So moved.
We have a motion.
Second.
We have a second. Without objection to so ordered. Any questions concerning the regulations or the staff amendments? Seeing none, please call the next regulation.
Chairman.
Yes. Representative Frazier.
Yes, thank you, Chairman West. Was the plumbing regulation brought forward at this time?
I'm sorry, I didn't hear you. Which regulation?
The regulation in regards to virtual plumbing inspections.
I'm getting a nod.
Yes, it was.
It should be 815 KAR 20150. That's correct.
And it is on the table for at this time?
It is on the table, yes.
Okay, I would like to ask some questions about that regulation.
Please proceed.
So just to give you a little background, my father-in-law is a master plumber. My husband was a master plumber, so I am somewhat versed in this area. And I guess I would like to know, is this in regards to rough-in inspections, final inspections, residential, commercial? I'd like to kind of be walked through the overview of this.
Sure. This is primarily for, I think one example when it comes up frequently when it would be useful is for a water heater inspection. There are aspects of rough-in inspections in residential properties when it would be appropriate, but this is primarily for those inspections when the master plumber involved and the department agree that that a visual inspection would be sufficient. I think the primary example is for a water heater.
May I ask some more questions?
Please proceed.
So, for example, in the case of even for a water heater, you know, I think the potential for fraud is here, even, you know, in as far as the size of the tank. If you were to put in a 50-gallon tank and have it inspected, then they could always be taken back out and a 20-gallon tank, you know, put in. And I know you give that as an example, but is this opening the door for all types, or are you saying only water heater inspections?
It would be for all types, but those are only in instances when the department feels that when a master plumber requests a remote inspection and the department deems that it is appropriate. In most instances, I still think that it would be considered appropriate for the department to physically go and conduct the inspection.
Is it drafted to be narrowly tailored in that way?
I believe so. You know, this in providing that the deference is still there for the department to consider when it is and is not appropriate.
Senator, may I continue?
You may.
So is this provision something that would expire when COVID has passed, or is this something that intends to be mandated for use ongoing?
No, ma'am, it would not expire once COVID has passed. You know, the time we've been in the pandemic has emphasized Obviously, it would allow for greater safety during the pandemic, but afterward, in instances when it's appropriate, it still would allow for time and money to be saved by master plumbers and by the department in those instances when it is appropriate.
So what would be a provision for, so at a rough end, an air pressure test is used, so it can be blocked off. What would prevent someone from making a block in another room where the inspector virtually could not see that that had taken place, so the other joints could be passed?
I think in that instance, if there were opportunity for something like that to happen, that would be an instance when the plumbing inspector would physically go. We wouldn't consider that a time when a virtual inspection would be sufficient, just because there would be that potential for a fraud, as you put it.
So again, is that stipulated in this regulation that the types of inspection would only pertain to water heaters?
No, it wouldn't only pertain to water heaters. What I said that earlier is just as an example of a time when it would be appropriate. But if there were a rough-in and a test needed to be done, then that would not be conducted remotely. If that's what you're asking, I apologize if I'm misunderstanding the question.
Senator, one final question.
Please proceed.
So with a virtual inspection, how could a cross connection between a sewer line and a water line be ensured? So to prevent contamination?
In that instance, I do believe that if, again, I want to emphasize that if there's any concern that something like that, there would be cross-contamination or something couldn't be appropriately inspected virtually, it would be done in person still. This is only in instances when a master plumber requests this and the department thinks the department determines that there is no opportunity for that kind of, missing something of that importance.
Senator, may I comment?
You may.
Sewer gas is highly explosive, and I think the potential for cross connections between water lines and sewer lines is not something that can be ensured from a virtual manner. And although I understand your intent for this only to be used and isolated in certain types of inspections, I think this is potentially opening a door that doesn't need to be opened. And I would like to move to find this reg deficient.
There's a motion on the table to find this reg deficient. As chair of the committee, I would, before I rule or proceed with that motion, would the department, seeing this motion, would they agree to a deferral on this particular regulation?
We would agree to a deferral.
Okay. Coming back to Representative Frazier, would you still like to proceed with your motion for deficiency, or would you like to withdraw your motion for deficiency and make a new motion, a motion for deferral?
I would like to make a new motion for deferral, and I appreciate the willingness to defer this. I think if the intent for this to be used in a narrow fashion, I think it needs to be spelled out in that narrow fashion and specifically list the instances when this can be used, would be my suggestion.
Mr. Chairman, just as a parliamentary rule, I believe we already had a motion and a second on this. I was the second, I think. So I would remove my second if I'm correct.
That's fine, Senator Kerr. My hearing may be bad. I didn't hear the second. So are you agreeing to remove your second from the motion for deficiency? Are you withdrawing that?
I'm withdrawing the original motion. I think, weren't we in the process, staff, with this, hadn't there already been a motion and a second made to not to defer, but to pass?
To find it deficient? We had not gotten to that
No,
point
a
yet.
previous motion.
The body will stand at ease. Hold on just a second. We think we have it figured out. Senator Kerr, what we think you heard, we had the staff amendment, and we had a motion on the staff amendment. We had a second, and we had no objections, and that was the amendments were ordered put in place. And then we had a motion for deficiency from Representative Frazier, and I nor committee staff heard the second on that particular motion.
I don't think there's been a motion made to second it yet.
We don't think so either. We didn't know if there was a.
I'll second the motion then to find it deficient.
I don't think we can right now because that's not the motion on the table. Representative Frazier has withdrawn her motion for deficiency.
Oh, okay. Okay. Thank you.
And she does now have on the table a motion for deferral. Do you wish to second her motion for deferral?
Yes, I'm getting my two D words mixed up. I wish to second the deferral motion from Representative Frazier.
Thank you. That's where we are. There is not a vote required on a motion for deferral, so I will order that from the chair. Do we have any objections to a roll call vote? The committee will stand at ease before we vote. Just a second. It's getting serious. We have lawyers coming. We have one lawyer coming. So I apologize for the delay. Well, we're back. What we've been discussing with up here is procedure as it pertains to members on campus or voting from home. And with COVID has brought us all kinds of interesting legal questions. The question we're dealing with primarily is, does your vote or does your motion count from home? It may or may not. So in other words, we're going to get back to the process as it pertains to 815 KR 020150. But before we do that, we would like to welcome Senator Adams to the committee in person at this moment. And I believe, do you wish to first record a vote on the Horse Racing Commission regulation?
Yes, thank you, Mr. Chairman. I was detained on a Zoom call on healthcare issues, so I'm glad to be in committee right now. I would like to record a vote as a yes to finding that Horse Racing Commission reg deficient. Is that
that's in order?
That's in order?
That's in order, and we will be coming back to that reg here shortly.
Thank you.
Thank you, Senator Adams. Back to the matter at hand. This is directed to Representative Frazier. Representative Frazier, there is a question, a legal question, as to whether or not your motion and vote would be in order since you are coming to us from home. Is that correct? Are you speaking to us from your house?
Yes, I'm in my home district, and I had made the comment in the chat that I did have a comment in regards to this reg.
Okay. So as chairman of the committee, I'm finding that your motion at this time is out of order because of that deferral motion. However, we do have a that would put the motion and the second out of order, but we do have a motion, I believe, coming from Co-Chair Hale.
Thank you, Co-Chair West, and thank you for diligence in getting everything correct and proper here. I would like to make the motion that we defer, or I would make the motion to defer regulation 020150, that we would defer that regulation at this time.
Second.
There being a motion on the table, having a second, I believe we have the second from Senator Kerr.
That is correct, and I'm in my office, which I can come down if you...
No, I believe if you're on campus, you're fine.
Yes, so, that was my understanding.
So we have a motion from Co-Chair Hale. We have a second from Senator Kerr. Without objection, it is so ordered. Regulation 815-20150 has been deferred. Now, do we have any other comments or questions on related to 815-35015 for the Department of Housing, Buildings, and Construction? Seeing none, please call the next regulation.
Cabinet for Health and Family Services, Department for Public Health, 902 KAR 45180. This has an agency amendment.
This regulation, as amended after comments, adds definitions, replaces the current and proposed fee structure for food manufacturing with a third structure that is tiered based on income and risk level. It establishes a $150 inspection fee for cosmetic manufacturers and establishes a $50 fee for a certificate of free sale. There is a proposed agency amendment which would amend Section 3 to revise the fee structure so that fees would now be based on the facility's square footage and the risk level of the food being processed or stored. For example, for smallest facilities, they would see a $5 to $15 increase compared to their existing fee. For largest facilities, it would be a $200 to $400 increase compared to their existing fee.
Would you please identify yourself for the record?
Yes, this is Julie Brooks, Regulation Coordinator for the Department for Public Health.
Do you have anyone else with you today?
No, sir, I do not.
Thank you. We have an agency amendment for this regulation. Would you please explain the agency amendment?
Sure. So after the last, I guess it was in the November committee meeting, we went back, the department went back and we looked at the fee structure and had several conversations about basing it on income and how that could fluctuate and change, and really didn't have a clear sense of how that would be defined. Plus that it would put the food processor, or primarily the food processor, in an awkward situation of having to disclose information that they don't normally disclose to our inspector. Currently, all facilities are permitted based on the square footage. So we felt that restoring the square footage permitting structure would be more fair and equitable, because that is less likely to vary year to year. We did keep the risk level tiering in the proposed fee structure. We also went back and looked at the dollar amounts and, tried to be, again, more fair and equitable to our smaller producers, to put less of an increase on them versus the larger facilities that, do have a higher income, but so it does kind of shift that burden with them.
Thank you. We have the agency amendment on the table. Is there a motion for approval of the agency amendment? I'll make the motion. Do we have a second on the agency? We have a motion and a second. Without objection, it is so ordered. We do, hold on just a minute. This committee will stand at any members have questions for the cabinet on this reg? Seeing none, I would just like to make a comment that I think this particular set of regulations is a great example of the process working here in Frankfort. The cabinet brought these regulations forward initially 2-3 months ago, and some legislators had some problems with it. We slowed things down here in this committee. The cabinet presented to the Ag Committee, Committee of Jurisdiction, and there was groups that worked together to fashion what we have before us today. And I would like to thank the cabinet for taking those comments and considerations into account. And so, Co-Chair Hale has a question or comment.
No question, Mr. Chairman. I would just like to echo your sentiments, what you said there, and to the agency. We appreciate this very much, and like Co-Chair West said, this is the way the process is supposed to work, and we had this deferral on this particular regulation a couple of months ago. I appreciate very much you working with the folks and bringing these fee structures back down, I think, to where that at this present time they should be. This agency provides a great public service through your inspections for the health and well-being of our citizens in these facilities. So thank you again for what you do. But more than that, or especially, I just want to say thank you for working and going through the process that we felt like we had a lot of questions about this, of the fees that were being imposed earlier. But again, just echoing what Senator West said, thank you all very much for working with us on that. I appreciate it.
You're welcome. And I want to say thank you to everyone who was willing to give us the time to work through this and support us as we made these changes. So thank you to Senator West and Representative Hale for your support in allowing us to work through this.
Thank you so much. Do we have any other questions from members of the committee on this set of regulations? Seeing none. Before we move to the next regulation, we need to do a little bit of housekeeping. This is procedurally, I think we're fine, but out of an abundance of caution, we are going to come back to the horse racing regulation that we found deficient.
810 KAR 3020.
We are going to take another vote on that particular set of regulations just to make sure that procedurally we're correct. So at this time, I would make a motion. I would withdraw my previous motion for deferral, and I would make a new motion for deferral. I'm sorry, I'm getting my D's mixed up, Senator Kerr. A motion for deficiency. I'll make a motion for deficiency.
And I would second that, sir.
So there is a motion for deficiency on the table. There's a second of that motion for deficiency. If the staff would call the roll.
Senator Rocky Adams. Senator Kerr.
Aye.
Senator Yates.
Aye.
Representative Bridges. Representative Frazier.
Yes.
Representative Hale.
Yes.
Representative Marzian. Senator West.
Aye.
We have 5 votes present at LRC and 2 in district. So either way, the motion carries.
Thank you so much. Thank you for that. Sorry for the confusion. Just want to make sure that we're doing everything by the book. We have before us next Department for Medicaid Services.
907 KAR 3250. This does not have additional amendments.
This regulation establishes participant eligibility standards, covered services, requirement for the PACE organization, excluded services, a requirement to establish an interdisciplinary team at each center, departmental monitoring of PACE organizations, corrective procedures, appeals and grievances procedures, and reimbursement policies and provisions.
Would you please identify yourself for the record?
Good morning. I'm Lisa Lee. I'm the Commissioner for the Department for Medicaid Services. I have with me Lee Geist, who is the Division Director for Policy and Operations, and also Jonathan Scott, who is the Legislative and Regulatory Affairs Advisor.
Okay. Any questions from members of the committee on this set of regulations? Seeing none, please call the next regulation. Thank you.
Department for Aging and Independent Living, 910 KAR 1151 and 2060. 060 has a staff suggested amendment.
910-1151 repeals 910 KAR 1150 program and certification requirements for the private pay adult day and Alzheimer's respite program, and 910 KAR 1160 program and certification requirements for the adult day and Alzheimer's respite program, because the statutory authorization for these regulations has been repealed. 910-2060 establishes requirements for the Guardianship Trust Fund pursuant to KRS 210-290, public notice, claiming funds, appealing decisions, matters not appealable, investments and disbursements, and the right of reimbursement of the trust. The staff suggested amendment amends various sections to comply with the drafting and formatting requirements of KRS Chapter 13A.
Would you please identify yourself for the record?
Good morning. My name is Victoria Elridge. I'm the Commissioner for the Department for Aging and Independent Living. I have other staff with me as well who will identify themselves.
I am Marnie Mountjoy. I'm Assistant Director in the Department for Aging and Independent Living.
Thank you.
Hi, I'm Phyllis Sosa. I'm the Staff Assistant.
Good morning. I'm Amy Metzger. I'm the Division Director here at the Department of Aging and Independent Living.
And I am Tanya Wells. I am the Division Director over Guardianship.
Okay, thank you. There's a staff amendment. Is there a motion for approval of the staff amendment?
Motion.
Do we have a second?
Second.
Just make a note that that was Senator Kerr who made the second. We have a motion and a second. Without objection, it is so ordered. Any questions from members of the committee on this set of regulations? Seeing none, please call the next regulation. Get these out of your way.
Department for Community-Based Services, 921 KAR 3020, 030 with agency amendment, 035 in emergency with agency amendment, 3042, and 922 KAR 1500.
921 KR 3020 amends to update resource limits for SNAP households to current amounts mandated by the USDA Food and Nutrition Service, remove interest income from list of income excluded from financial review, establish a SNAP household disqualification for one-time lottery or gambling winnings in excess of $3,500, and replace term alien with immigrant for consistency with federal programs and definitions. 921 KR 3030 amends to clarify households denied or disqualified due to receipt of one-time lottery or gambling winnings in excess of $3,500 are not categorically eligible for public assistance, and replace term alien with immigrant. The agency amendment amends Section 9 and incorporated material to make technical corrections. 921 KR 3030 in emergency amends to extend SNAP certification period from 12 to 24 months for households including elderly members or members with a disability and no earned income, extends SNAP certification period from 6 to 12 months for households including members who are not able-bodied adults without dependents or elderly or disabled with no earned income, remove reference to the disqualification of a household member who is a non-custodial parent with child support arrears as this program disqualification no longer exists, and update a form. The agency amendment amends Section 8 and incorporated material to make technical corrections. 921 KR 3042 amends to establish provisions required by the 2018 Farm Act for education and training programs, remove outdated provisions relating to the Work Experience Program, and revise the incorporated form. 922 KR 1500 amends to update material incorporated by reference and include a reference to a federal program for consistency with the federal rule.
Would you please identify yourself for the record?
Good morning. My name is Laura Beacon, and I'm the Regulation Coordinator for the Department for Community-Based Services.
I
believe Paula Sons is joining me.
You might want to turn your volume up.
Sorry about that.
That's okay.
Good morning.
Paula,
My name is Good morning. My name is Paula Sines. I work for the Department of Community-Based Services in the Division of Protection and Permanency.
Thank you. We have agency amendments for these regulations. Is there any discussion of the agency amendments?
Mr. Chair, just a quick question, if I may.
You may. Senator Yates.
Thank you. Obviously, especially at now's time, I can see the need to be proactive with these. My only concern is when you read out the lottery set aside, and I know one of the real problems with our lottery is the way it exploits the poor, and that I think it was showing that of the, and I think it maybe 70 billion in lottery tickets, that more than half of it came from people making less than $28,000 a year, and that nationwide, that people who are making less than $10,000 a year spend an average of almost $600 a year on lottery tickets. And so I just wouldn't want to do anything to encourage the use or to spending the very limited resources on that very unattainable dream of the lottery. Obviously, I don't know what kind of effect this will have on whether or not it'll keep people from playing the lottery or not. But in my personal injury practice, I've seen that a lot. Clients who are really struggling, bad car wrecks, may have lost a job, have very, very limited resources, yet they're playing the lottery with the hopes of winning big somehow. And we'll sit down and we'll talk about, you realize you've spent $1,000 this year on that, or, anyway, that was my only a little bit of concern, because I know that you can't make a requirement that if you're receiving these benefits or doing this, that how you're going to be able to spend your the little bit of money you do. But I think that we've got to work to be able to educate people better, especially as a state, as we continue to see that expand. And so I really, more than a comment, that's the only thing that really does worry me. Anytime we mention the lottery as it relates to SNAP benefits, I think that needs to be mentioned. And if any of you can comment if that's been a problem, or there's any kind of education that you guys do with your interaction with the individual members who are on benefits, if there's anything we're doing to better educate, to let them know that this is a prey on the poor, and that and not a good use of their money.
I'll jump in, Senator Yates, if you don't mind. I agree with many of your comments that as stated. The cabinet can chime in here, but I believe that this particular regulation is attempted to be put in place because we are conforming with federal guidelines. So I think the $3,500 is an attempt to step up to the new two federal guidelines, and they can comment on that.
Yes, sir. I will say that just for everyone's information, that SNAP public assistance, of course, cannot be used for the lottery. It can only be used for, I just wanted to put that out there, for only eligible food purchases. So there are pretty strict criteria about that. And Chairman West is correct that these amendments relating to lottery are required by the 2018 Farm Act, and they just include a disqualification for SNAP applicants or recipients if they have one-time lottery or gambling winnings of $3,500 or more. So in some ways, you might say that it could be a slight deterrent to lottery if they want to continue to receive SNAP assistance. But that's really as far as these regulations go pertaining to lottery.
Mr. Chair, if I may.
You may.
I just wanted to say I appreciate that, and I apologize for any of my ignorance on this. This is my first committee meeting, and so I appreciate that explanation. Thank you.
Thank you. Do we have any other? We're going to take these in order. Do we have any other comments on 921-3020? That's the SNAP benefits pertaining, and it involves lottery winnings, gambling winnings. Seeing no further comments on that, we'll move down the list to 921-KR-3035. Do any members of the committee have any questions on that? I'm going to hold on just a second. The committee will stand at ease. I'm good. Before I proceed any further, I'm going to ask for approval of the agency amendments. Do we have a motion on approval of the agency amendments? We have a motion. Do we have a second? We have a motion for approval of the agency amendments. Do we have a second?
Second.
We have a motion and a second. Without objection, it is so ordered. So before us, we have all these regulations with agency amendments attached, except for the third one, 3042. Any questions on 921-3035 at this time from members of the committee? Seeing none, I have a few myself. First of all, could the cabinet just give us a brief overview of this set of regulations and what they're doing?
Sure. Are you referring to 921-KR-3035, emergency and ordinary?
I'm so sorry. We're having a hard time hearing your comments. If you could turn that volume up. If you could say that one more time. I apologize.
Yes, no problem. Sorry.
We can hear you perfectly now.
Okay, thank you. I just wanted to clarify, are you asking for specific information on 921 KAR 30335 emergency and ordinary, or other regulations as well?
No, just that particular one. Just that
Sure,
particular.
no problem. So it was filed as emergency and ordinary back last summer. The administrative regulation changes the certification periods for SNAP. It lengthens those certification periods. This was something that we wanted to do emergency so that no SNAP recipients are negatively affected by certification, especially during the pandemic. SNAP is used for assistance in purchasing food for low-income families throughout Kentucky, and we just wanted to ensure that there were no certification errors and anyone was inadvertently kicked off of receiving that assistance in purchasing food during the pandemic, especially when resources were not always available and food scarcity issues.
So does this?
Go ahead. Sorry.
It's okay. Does this regulation? How does it treat non-custodial parents who are delinquent in court-ordered child support?
Yes, it did make a conforming amendment with another administrative regulation that had already gone into effect that eliminated the disqualification. So it's not unique or original to this amendment, but this was a conforming amendment in this administrative regulation that does delete reference to that disqualification.
So
and if you'll see there, that other administrative regulation is referenced in that deleted portion.
Yes, thank you. So does this extend the time frame for which recipients can receive SNAP benefits?
It extends the time period for which they would undergo recertification to see if they are still eligible.
So it would not extend it from 6 months to 12 months?
That period of time where we check to make sure that they are still eligible for the program, it does. Now, if they have something that disqualifies them, they are responsible to submit that to us. So, for example, if they had lottery winnings above $3,500, they would need to submit that to us and then would be disqualified from the program. But as far as us just doing administrative work to make sure that they are still eligible, that time period was extended through this amendment.
So compare this regulation to the regulation that we found deficient. That the Interim Joint Committee on Health and Welfare found deficient on September 23rd.
This makes a conforming amendment with that administrative regulation. So again, the child support arrears reference in this administrative regulation, that is not a new issue to this reg, but it did reference that other administrative
So
regulation.
there are no differences. It completely conforms.
It conforms with that amendment, yes.
Okay.
In deleting that reference to disqualification.
Do we have any other questions from any members on this? Co-Chair Hale.
Thank you, Senator. I just have one quick question. During this, and it's just some information I was reading over here, but during this pandemic that we've been in, about how many Kentuckians have qualified for these benefits, SNAP benefits? Do you have a number there?
I do not. Unfortunately, my program expert had a scheduling conflict, but I will see if he can get back on real quick.
And just to follow up, has there been a significant increase?
I'm not aware of that off the top of my head. I can get that information for you and see if a program expert can get back on this.
if you could just get me that information, I'd appreciate that. Thank you. Thank you, Mr. Chair.
Committee will stand at ease. I have a question regarding what is the impetus behind bringing this forward? Did the legislature not intend that non-custodial parents who were delinquent on their child support stop receiving SNAP benefits or have those delayed? Wasn't that the intent of the legislature?
That was the intent of the legislature, but that administrative regulation is still in effect, and it was in effect at the time that these administrative regulations were filed back in summer. That's why that change was originally made in the regulations.
So I guess I'm confused. So if the intent of the legislature was to try to make sure that parents, non-custodial parents who were delinquent in court-ordered child support payments did not receive SNAP benefits, then why are we doing through the administrative reg process that they should receive SNAP benefits? Why that change in December and September, and then why come back now after the Committee on Health and Welfare has found that set of regs deficient? I guess I'm missing something, I think.
Yes, sir. It's really a matter of process. This regulation, which, as you know, an emergency administrative regulation cannot be amended, was already was filed last summer before the other administrative regulation that this one references was found deficient. So it's a matter of this regulation already being filed, why it contains that deletion to that reference in this reg, and that other regulation that this references is in effect still without that disqualification.
Well, that's my question. I think maybe you're misunderstanding my question. I think the regulation in September was not carrying out legislative intent, and so it was found deficient, and so we're filing another regulation that doesn't carry out legislative intent. It appears to me we're attempting to make policy, public policy, through regulation here, through the agency. Is that, am I wrong there? Why am I? Tell me how I'm wrong.
Well, I believe staff can explain why this is needed for consistency with the other administrative regulation, because the deleted language in this regulation, what it's referencing in the other regulation, is no longer there. This regulation deletes reference to section 11 of the other administrative regulation, and that regulation no longer contains the section 11.
Thank you. Do we have any other questions from members of the committee? Co-Chair Hale.
Again, I come back to Senator West. Your comments are spot on. I mean, we had this regulation was found deficient by the interim Health and Welfare Committee in September, and the governor has put this regulation back into effect, notwithstanding the deficiency that was found by the interim committee. And so, again, my question would be similar to Senator West, and I don't think we got an answer that would that we felt was proper there. Why is this being brought back to us again?
I see. I will defer to my colleague in just a minute. I just wanted to add that the disqualification for child support arrears is not being made in this regulation. This regulation did not include that disqualification. This administrative regulation included a reference to the disqualification. So the deleted language here is a reference to that regulation. The change is not being done again in this reg, but I'll defer to my colleague Donna Little in case she would like to explain.
This is Donna Little, Deputy Executive Director for the Office of Legislative and Regulatory Affairs with the Cabinet for Health and Family Services. And Laura is correct. The regulation that's before you today, 921 KAR 3035, includes a cross-reference to another regulation. This regulation was filed prior to the finding of deficiency of the other regulation. However, this reg has a cross-reference now to a citation in 921-3025, Section 311, that no longer exists. We have asked the reg staff on previous occasions if cross-references that are incorrect can be removed via a technical amendment, and they have said that you have to go through the regs process with a full, the full 7 to 10 month process to make changes. And that's what this regulation is doing. It is changing that reference because there is a bad cross-reference. It's cross-referencing to a subsection that no longer exists. And that's all that this one is doing in regards to that issue, is it's deleting an incorrect citation.
Yeah, I think I have less of a problem with the process than I have with actually what is in the regulation itself. So while Senator Adams is here, before she gets away, she has to leave us here in a minute to present a bill. I'm going to ask the agency if they would agree to defer this regulation so we can discuss this further, so it can be discussed further.
Yes, we will agree to that deferral, sir.
I really appreciate that. So I'll make a motion. I will make a motion for deferral of this particular regulation. We have a motion and a second. Without objection, it is so ordered. And I want to thank the agency for agreeing to that. That's just 921 KR 3035. Do we have any other questions on any regulations in this set of regulations? Seeing none, please call the next regulation. Thank you.
That concludes our agenda for today. Our next meeting, we are looking at February 8th, which is a Monday at 10 a.m.
Committee, take note. Next meeting is February 8th at 10 a.m.
Mr. Chairman, I prefer that time. I prefer that time to this 8 o'clock meeting. I just wanted to voice that.
Senator Kerr, just so you know, it was not my decision. It was circumstances beyond my control.
I jest.
And let me add beyond